Judgment in the matter of an application by Rosaleen Dalton for judicial review.
In this case, the court is considering how far into the past, before the Human Rights Act was brought into force on 2nd October 2000, do the obligations to investigate a death under the European Convention on Human Rights, as applied domestically by that Act, extend? What are the matters to which the court may have regard in making that assessment? This appeal, which has been determined by a bench of 7 justices, addresses those questions. The background is one of the many tragedies which occurred in Northern Ireland during what was called the Troubles. Mr. Sean Dalton was killed by a bomb planted by the Provisional IRA in August 1988, when he and 2 others entered the flat of a vulnerable person whom they had not seen for some time, and about whose welfare they were concerned. Unknown to the victims of the blast, who were acting as good Samaritans, the vulnerable person had been abducted by the IRA, who planted a bomb in his flat as an ambush for the security services. It is alleged that the security services had become aware that there was a bomb in the vicinity of the block of flats in question, but did not warn the local community of that intelligence. The police investigated the deaths, but did not charge anyone with the murders. An inquest in December 1989 found that Mr. Dalton had died from injuries suffered in the explosion. Mr. Dalton's son lodged a complaint with the Police Ombudsman of Northern Ireland about the behaviour of the police before the killing and in its investigation. In a report in 2013, the Ombudsman was critical of the police, concluding that they had failed properly to investigate the death. The Ombudsman also noted that his investigation was hampered by missing documents and the refusal of some retired police officers to cooperate with the investigation. Mr. Dalton's family asked the Attorney General of Northern Ireland, whom I'll refer to as the Attorney General, to open a fresh inquest into the death, pointing out that a coroner, unlike the Ombudsman, could compel witnesses to answer questions. The Attorney General refused that request, stating that there was no obligation to investigate further the death under Article 2 of the Convention, where the inquest was not likely to lead to the identification and punishment of those responsible for the bomb. He also stated that an inquest was not advisable, having regard to the Ombudsman's report and the existence of civil proceedings by the family against the police. Mr. Dalton's daughter commenced judicial review proceedings to challenge the Attorney General's decision. The High Court dismissed her challenge, but the Court of Appeal of Northern Ireland allowed her appeal and remitted the matter to the Attorney General for reconsideration. The Attorney General appeals to this court. This court unanimously allows the Attorney General's appeal. That's the simple bit. But there are 4 judgments, and each of the justices has contributed to one or other of them, and they contain differing degrees of emphasis. There is also disagreement in the court on the correct interpretation of the jurisprudence of the European Court of Human Rights concerning the retrospective effect of the European Convention on the international plane. That is, the circumstances in which the Strasbourg Court has jurisdiction in relation to the investigation of deaths that occurred at a date before the country in question conferred a right of individual petition to that court. That jurisprudence is relevant as an analogy to the question facing this court on the domestic plane. The Strasbourg Court has had several attempts at defining the temporal scope of the Convention, and the House of Lords, and more recently the Supreme Court, has grappled in many cases with the analogous question of the temporal scope in domestic law of the Human Rights Act. In this address, I will not focus on those disagreements, which have resulted in a rather lengthy compendium of judgments, but on the main reasoning of the court, which sets out the rules that are applicable. Firstly, a majority of judges disagree with the wide multifactorial reasoning which they consider that this court adopted in the earlier case in 2019 concerning the death of the solicitor Patrick Finucane. But this court is in agreement that we should not depart from the decision in Finucane. Secondly, the correct analysis of the temporal scope of the Human Rights Act in relation to the investigation of deaths occurring before its commencement was correctly set out in the obiter dicta in paragraph 144 of the later case of McQuillan, which this court decided in 2021, subject to some minor amendments for clarification. Thirdly, that means that in our domestic law, the obligation to investigate deaths under Article 2 of the Convention can only apply to deaths which occurred within 12 years before the Human Rights Act came into force on 2nd October 2000. That is an outer limit. If the death occurred more than 12 years before that date, the proceedings for breach of that article will be struck out. The only exception to that rule is what the Strasbourg Court calls the Convention Values Test. If that test is met, that is, if the incident is a fundamental attack on the values of the Convention. This is an extremely high hurdle for someone seeking to rely on it. It's principally concerned with serious crimes under international law, such as war crimes, genocide, or crimes against humanity. Fourthly, leaving to one side the Convention Values Test, if the death occurred between 10 years and 12 years before 2nd October 2000, then the claim may be brought only in exceptional circumstances. Those circumstances are, firstly, that the original investigation into the death can be seen to have been seriously deficient or non-existent. And secondly, the bulk of the investigative effort which has taken place or ought to have taken place post-dates 2nd October 2000. There are therefore two fixed periods, an inner limit of 10 years, by analogy with what is at least a norm in Strasbourg jurisprudence, and an outer limit of 12 years if the exceptional circumstances which I have just mentioned in my fourth point exist. This combines certainty with a degree of flexibility. Fifthly, even if the death occurred less than 10 years before 2nd October 2000, it must still be shown that a major part of the investigation took place or ought to have taken place after that date. As Mr Dalton's death occurred more than 12 years before 2nd October 2000, the domestic courts do not have jurisdiction under the Human Rights Act in relation to his death, and the Attorney General's appeal succeeds. I should mention two further points. 6 of the justices held, contrary to the Attorney General's submission, that the Article 2 obligation to investigate and the revival of that obligation are not confined solely to investigations which may lead to the identification and punishment of the perpetrators. Secondly, Lord Legate, Lord Burrows and Dame Siobhan Keegan consider that the obligation to investigate was satisfied by the Ombudsman report, and Lord Hodge, Lord Sales and Lady Rose, without ruling on the point, consider that that is strongly arguable. They point out that the current proceedings provide scope for the involvement of the families and the detailed examination of the facts. The court will now adjourn.